Thank you, Mr. Chairman. Senator Sessions, if I might, I'd like to take us to an area I don't think has been explored much today, but of grave concern to me, which is disability rights. Another area where, if confirmed as Attorney General, you'd be charged with protecting among the most vulnerable Americans and those whose rights have only recently been fully recognized and enforced. You've previously said that the IDEA, which provides for access to education for those with intellectual disabilities, creates, and I think I quote here, lawsuit after lawsuit, special treatment for certain children, and is a big factor in accelerating the decline in civility in classrooms all over America. And in a different setting, you were critical of the Supreme Court's decision in Atkins versus Virginia in 2002, which held that executing individuals with intellectual disabilities violates the Eighth Amendment. In a floor speech 6 days later after that ruling, you said that you were, quote, very troubled by the court telling states, quote, they could not execute people who were retarded. If a state was scheduled to execute someone with intellectual disabilities, would you insist on the Justice Department now taking vigorous action to stop it? And given your previous comments about the IDEA, do you still believe it unfairly benefits some children and hurts others?
We made real reform in IDEA. I led that effort. We ended up having the vote of Hillary Clinton and Dick Durbin, Senator Durbin. We worked on it very hard, and I was very pleased with the way it worked out. It was true that the IDEA community pushed back against the reforms I was proposing, but in the end, I think it worked out fine. And the reason was that the burden was on the school systems. I was in a blue ribbon, great little school in Alabama, the first day of school, and the principal told me, it's now 3 o'clock. At 5 o'clock, I will go to a meeting with lawyers and parents about a child on whether or not they will be in the classroom all day or half a day. And the child had serious disabilities. So he said, I'm trying to get this school up and running, and I'm having to spend this extraordinary amount of time on this. So we created a legal system that made it better. And the schools got a little more deference in being able to monitor it. And it was a big issue. It was a disruptive force in big city schools in New York and Chicago and other places like that. So on the question of intellectual disabilities, I suppose we can disagree as a matter of policy. Perhaps I was questioning the legal mandate, but it depends. A person with intellectual disabilities, that should be considered as a factor in the sentencing jury or the judge's opinion before they go forward. But obviously, if a person knows the difference in right and wrong, historically, they would be held to the same standard, even though their intellectual ability would be less.
Let me revisit a question about consent decrees that Senator Hirono was asking about previously, because consent decrees have been used in this area in disability rights to make sure that folks with intellectual disabilities have access to services and education, but also in policing. Police chiefs and elected officials, as we've spoken about, in communities across the country, have in some cases invited DOJ to open civil rights investigations of their police departments and have invited them to enter into consent decrees in order to implement reforms to law enforcement in order to make sure that they improve the quality of police-community relations and respect for civil rights. Do you plan to continue to assist cities with these investigations when asked, if Attorney General? And under what circumstances would you commence a civil rights investigation of a law enforcement agency that may have violated federal law?
Well, those are difficult questions for me to answer explicitly today, but I would note on the consent decrees or the language Senator Hirono quoted, I believe was in a booklet of which I simply wrote the foreword on. I don't believe that was my language. Consent decrees have been criticized in a number of areas, but with regard to the disabilities community and the police departments, I guess you're asking about, I'm not familiar with how they've worked out in the disabilities arena, but with regard to police departments, I think it's a good thing that a police department might call on federal investigators and a team to work with their police department to identify any problems and to help select remedies that the community might feel were more valid because the Department of Justice validated them and agreed to them. So as I think you and I talked, it really is important that the people trust the police departments, and the police departments have respect from the communities. And when you don't have that, crime is people's safety is at risk.
Well, I hope we can find ways to continue to work together to combat violent crime and to improve police-community relations. Let me just briefly ask you about trade secret theft and intellectual property, something we've also talked about. There is a significant problem for American inventions, companies, entrepreneurs of having their innovations stolen, sometimes by cyber hack, by intrusion, sometimes physically or through industrial espionage. The Obama administration's made real progress in increasing enforcement and in going after those who would steal America's inventions. Is that something that you would intend to continue, vigorous enforcement to protect American inventions?
I do. I think a lot of that may be through the U.S. Trade Representative. It could be done through Commerce Department and other departments, and the Department of Justice may have a role in criminal activities or civil enforcement. I would not, excuse me, say for certain what that role would be at this point. But my view, as you and I have talked, is that you're correct about this. When we enter into a trade agreement with a foreign nation, what we have to understand is that's just a simple contract. And we'll comply, we'll deal with you on this basis, and if your partner to that contract is not acting honorably, then you have every right to push back. And if it ultimately means you have to pull out of the agreement, then you pull out of the agreement if it's serious enough. I don't think we've been as aggressive as we should have been in those agreements.
Let me ask one last question, if I may, Mr. Chairman. I just wanted to reflect on something you said in your opening and something we have talked about. You were born in Selma roughly 70 years ago. I've been to Selma several times with Congressman Lewis and a number of others. And last year, many of us joined Congressman Lewis for the 50th anniversary of that famous march across the Edmund Pettus Bridge when he faced violence, and the response, the conscience of the nation was stirred by this horrible event. And it spurred Congress to pass the Bipartisan Voting Rights Act. There's been a lot of questioning back and forth about your comments about whether the Voting Rights Act was intrusive and the Shelby County decision. And I just wanted to make sure I came back to an important point, which was that Senator Leahy and I and a number of others tried hard to find Republican partners to advance the Voting Rights Advancement Act, which would have replaced the now 50 years old, roughly, pre-clearance formula with a new one that would be national in scope, would not disadvantage any region, and would be simply based on enforcement actions. Previous questioning by, I think, Senator Franken and others focused on recent enforcement actions. The Fourth Circuit finding that North Carolina's post-Shelby voter ID law violated the law because it targeted African Americans. You said in your opening statement that you witnessed the civil rights movement as it happened near you, that you witnessed the depredations of segregation. And in a ceremony last year during the presentation of the Congressional Gold Medal to the foot soldiers of the civil rights movement, you said, "I feel I should have stepped forward more." What more do you think you perhaps could have done or should have done in recent years as a senator to take more active action so that folks from around the country could have confidence in your commitment to continuing the journey of civil rights in this country?
Well, I don't think we have to agree on everything. Just because you think this was a necessary thing, you may be right, and if I don't think so, I don't know that I'm wrong, not necessarily wrong. I would say that I did sponsor the Congressional Gold Medal Act that gave the gold medal to the Selma and Montgomery marches with Senator Cory Booker.
Yes.
We were the two lead sponsors on it. I was at that event and have a wonderful picture I cherish with John Lewis and other people on the bridge celebrating that event. It changed the whole South. voting rights were discriminating, African Americans were being discriminated against systematically. They were being flat denied through all kinds of mechanisms, and only a very few, in many instances, were allowed to vote, if any. So this was an unacceptable thing. As I said at the hearing in 1986, I was asked about it being intrusive. Please, Senator Coons, do not suggest in any way that that word means that I was hostile to the act. And I said then, and I say now, it was necessary that the act be intrusive because it had to force change, and it wouldn't have happened without the power of the federal government. That is a plain fact.
Senator, what I'm suggesting is an alternative path forward for the Voting Rights Act that would not have been singling out one region or one state or one history, but that would have allowed the Voting Rights Act to continue to be effective in the face of the recent record showing ongoing discrimination, ongoing denial of the right to vote in different states across the country, now no longer isolated to the South. When presented with an opportunity to continue and strengthen the Voting Rights Act post-Shelby, you didn't take that step.
Well,
Senator Sessions, if you need to answer that, go ahead and answer it.
I'll be
I
short.
want to go to Senator Blumenthal.
As I said, I supported the reauthorization of the Voting Rights Act with Section 5 in it. When the Supreme Court said it was no longer necessary that Section 5 be in it, I did not support the language that you offered that would basically put it back in, you and Senator Leahy. So I don't apologize for that. I think that was a legitimate decision. And with regard to the question of voter ID, I'm not sure it's been conclusively settled one way or the other whether a properly conducted voter ID system is improper and discriminatory. Indeed, the Supreme Court has held that voter ID is legitimate, at least under certain circumstances.